Thank you, Grace, so much. And thank you to everybody for being here. We have such an amazing and diverse audience here with us today for this conversation. So as Grace mentioned, my name is Alicia Virani. I'm the director of the Criminal Justice Program, and we are incredibly proud to co-sponsor this important event today. Briefly, the Criminal Justice Program is a program of the law school that provides education and training for our students in several key areas of focus, including police brutality and accountability, criminal law and immigration enforcement, criminal defense, collateral consequences of criminal convictions, juvenile justice and the family regulation system, restorative and transformative justice, and alternatives to policing and prosecution. I'm grateful to be here for this conversation because our incredible panelists have so much insight about the impact of long-term sentencing on people incarcerated in California. The demands to release people who have served long periods of time in custody are growing louder and gaining traction. These advocacy efforts have had some impact on securing some early releases during the COVID-19 pandemic, at least in prisons. But there's still more work to be done, as always. Carceral sentences come with forced labor, family separation, and incredibly deficient health care, all of which have significant and long-term impacts on the physical and mental health of people who are incarcerated. When folks are able to secure release through the parole process or finishing out their term, reentry services are often lacking, and there are systemic barriers to being able to access the workforce, government benefits, and other basic survival mechanisms to ensure that people who are released have what is needed to thrive. Our panelists will discuss all of this and more through an intersectional lens that focuses particularly on women, gender nonconforming, and trans folks of color, and the elderly population incarcerated in California's prisons. Each panelist will give their opening remarks addressing what brings them to this work and describing the problems with long-term sentencing that they are all working to dismantle. I'll then facilitate a conversation between the panelists and then open it up to audience questions. And so without further ado, I'll hand it over to Romarilyn for your opening remarks.
Thank you so much, Elisa. Thank you, Grace. Welcome everyone to this conversation. I'm really excited to be a part of this panel. My name is Romarilyn Ralston. I'm an advocate with the California Coalition for Women Prisoners, the program director for Project Rebound at Cal State University Fullerton, a former life prisoner, feminist, and abolitionist. Last year, I worked on AB 2542, the Racial Justice Act, which was signed into law. The Racial Justice Act prohibits prosecutors from seeking, obtaining, or imposing a conviction on sentences based on race. It empowers defendants to challenge racial biasness in their case. And in working on this bill, what we found was a number of racial disparities in California that were extremely alarming. Black youth, both male and female, charged with offenses were more likely to be assigned to adult court at a rate of 91 per 100,000 cases, while their white counterparts faced the same fate at a very low 8 per 100,000 cases. Blacks and Latinx people make up 90% of the adults charged with gang enhancements in state prisons. And an overwhelming majority of people serving life without the possibility of parole sentences are Black, Latinx, multiracial, making up 68% of the overall 5,200 folks serving death by incarceration. Blacks and Latinx, Asians, and Native Americans also make up more than half of the people currently on death row. Californians' overall incarceration rate between Blacks and whites is 9-1. It is no doubt that the color of life in prison is Black. Long-term sentences are costly on our families, our communities, and those who are serving those sentences. The average cost of incarceration per adult is over $81,000 per year, and our corrections budget for 2021 is over $13 billion. It is extremely expensive to house people in cages for long terms. And as Alicia mentioned, collateral consequences. The American Bar Association estimates that people who have criminal convictions face over 48,000 collateral consequences. 48,000. 48,000 barriers, challenges, discriminations, stigmas, and disenfranchisements. Now, when you add aging to the list, those over 50 years old, and decades of incarceration, it's criminal. It's criminal to treat people like this, some of our most vulnerable citizens. In a 2017 sentencing report, California ranked #1 incarcerating people serving life sentences. It's not something that California should be proud of. And just to show that it's not just the sentencing reports evidence, but also CDCR's 2019 report also estimated that there's over 40,000 people serving life sentences, life without the possibility of parole, or condemned in California prisons. We are leading the way with life sentences, virtual life, death sentences, and life without the possibility of parole. And we need to change that. 68% of people sentenced to life without the possibility of parole, and I'll start saying LWOP for short, are Black and Latinx. 62% of people sentenced in California were under the age of 25 when they committed their offense. And we all know what the brain science is behind those who commit crimes when they are younger than 25 or younger than 18. They don't have the culpability to know exactly what the ramifications of their actions are. And 71% of people sentenced to LWOP are convicted for the first time. Lifers and people serving long sentences work for decades in prison, doing a number of jobs, facilitating groups, leading organizations, providing training for prison staff and those incarcerated, and work in a number of prison industries at very, very low wages, and sometimes no compensation at all. The average pay for incarcerated long-termers ranged between nothing and $1 an hour. Incarcerated people must work. We don't have an option. It is mandated by the penal code that all able-bodied people must have a job when they're incarcerated. And as a former lifer, I worked for decades in a number of jobs, and my highest monthly pay was $56 a month. And what's worse than earning $2.96 a day is paroling without savings, retirement benefits, or proper financial stability. Incarcerated workers are state employees and should be treated as such. And I think returning seniors should have retirement benefits. Over the past 3 years, I've worked on a number of critical criminal justice policy reforms. And together we eliminated sentencing enhancements with Senate Bill 1393 and Senate Bill 136. We reduced the burden of incarceration on incarcerated people and their families with Assembly Bill 2533 and Assembly Bill 45. And we added protections for formerly incarcerated students with Senate Bill 776 and Senate Bill 118. And we championed the historic landmark piece of legislation, Assembly Bill 2542, the Racial Justice Act. I'll end by saying there are many problems with long-term sentencing, and I'm committed to continuing the work towards abolition in coalition with organizations across California and across the country. We're all working to document, decarcerate, decriminalize, and dismantle systems of oppression as we dream of a world without prisons. And I'll just end with a quote from the beautiful, wonderful Ruthie Wilson Gilmore with a slight twist. Abolition is presence of what we need, and we don't need long-term sentences or prisons. Thank you so much.
Thank you so much, Romarilyn, and for that wonderful quote at the end. And I'll pass it on to Jane.
Good afternoon, everyone, and thank you to the Center for the Study of Women, for the Public Defender's Office, and UCLA School of Law for hosting this great event, and thank you to all of our participants for being here. Thank you, Grace, for the great introduction. I appreciate it. Mass incarceration has been with us for decades, and while there have been reductions in the California prison system, there's one prison population that has steadily increased, and that's the elderly incarcerated. Sources indicate that if we continue down the same path that we've been following, by the year 2030, that's just 9 years away, the elderly incarcerated population will be greater than 4,000% than it was in 1981. The reasons for this continued growth are twofold. First, as Romarilyn has said, it's the increased imposition of life sentences in California, as well as other draconian measures, always adding enhancements, new legislation. And the second factor is the delayed grant of parole. As Romarilyn said, California leads the nation in the imposition of life sentences, but the magnitude of it. Nationally, 1 in 9 individuals in state and federal prisons is serving a life sentence. Here in California, that's closer to 1 in 3. The continued incarceration of elderly makes no sense. Elderly have the lowest recidivism rate, according to research, about 3%. And they're therefore thus the safest to release. Elderly are also the most expensive to incarcerate, costing taxpayers 2 to 3 times the astronomical $81,000 per prisoner per year that California now spends to keep people behind bars. So a little cost check. There are about 30,000 prisoners age 50 and up in the California prisons today. At an average cost of $200,000 per year, that's 2.5 times the $81,000 that we just mentioned. That adds up to $6 billion, billion with a B. Let's say we release 80% of those. That's a savings to taxpayers of $4.8 billion. And what could we do with that $4.8 billion? What real public safety could we instill in our communities? Think of the social supports for the underprivileged, for the disenfranchised. So there's a solution here. Change the existing parole policy for elderly, but more importantly, change the existing parole practice to release more elderly. Some progress has been made. Elderly parole was required by the federal courts in 2014, and it was later codified into California law to refer all those age 60 and up with 25 years in for consideration for parole. That law has since been upgraded to refer those who are 50 and up with 20 years in. But there's a problem. There's always a catch, right? While these individuals are referred for parole consideration, they're not being found suitable. In fact, the parole suitability rate for elderly has been at about 26%, fully 10 percentage points below all other parole suitability rates. Now, this makes no sense at all. In my brief, I offer 3 typical examples of parole hearings for elderly, and I can assure you they are typical. Of the plus or minus 400 women at CIW now, age 55 and up, and I believe I know many of them as I was head of the Golden Girls group for many years. Most are here for a single crime committed many years ago under the duress of domestic violence. They have no prior criminal history. Most have been disciplinary free their entire prison. They've spent their years behind bars bettering themselves and their community. They pose little to no risk to public safety when released to the community. So why is the parole board not releasing these elderly? Probably a better question for the parole commissioners, but I have 2 thoughts on it. Number 1, parole suitability should not be such a subjective process, relying on a 2-hour interview to determine the all-important insight and remorse. And the most common reason for denial of parole is the lack of insight or the lack of remorse. After all, as people age, they lose cognitive abilities to effectively articulate insight or remorse. It should be a much more objective process. More weight given to their history in prison, the psychological evaluation, the years disciplinary free, and participation in education and self-help groups. The second factor, and commissioners are well aware that their parole suitability rate is tracked by victims' rights groups. And by the way, victims' rights groups are largely funded by the CCPOA, that's the Prison Guards Union. They know that higher parole suitability rates will be used against them in their annual legislative review, so they're cautious. And as a commissioner evaluating an elderly individual who's been denied parole perhaps 4 or 5 or 10 times, do they want to be the one commissioner to now grant parole? So perhaps there's a built-in bias to not go against what previous commissioners have laid down. All I can say is the statistics speak for themselves. 26% when it's very clear this is the safest population to release. So the solution is change the existing parole policy, and I would recommend age 50 and up, which we already have, and 10 years in. Research shows that incarceration beyond 10 years is counterproductive anyway. And pressure the BPH to follow the science, release more elderly. As Romarilyn has said, I'm committed to doing this for the rest of the years that I have and abolishing the prison system. Thank you.
Thank you, Jane, and for all your work on this important issue. And I'll turn it over to Ricardo. Oh, you're muted, Ricardo.
Yeah, sorry about that. I want to thank the Center for the Study of Women and Grace for making this possible. You know, I had these prepared remarks that I wanted to say that I thought would be so important. But after listening to Romarilyn and to Jane, I was reminded ever so clearly why I wanted to be a part of this conversation. There is nothing I can tell you as a public defender, as the public defender, about the statistics in prison of imprisoned individuals, about the impact on their lives while they're there, about the injustices that they experience in that caged environment, and the brutal reality that they must face when they come out of prison, often elderly and disadvantaged even more so. They would do justice to the message that Romarilyn and Jane have communicated in their opening statements, and I'm sure will continue to communicate in this conversation. I was reminded, though, of why I wanted to be here. As a public defender, a trial lawyer for over 22 years, and having done the most serious of cases for the majority of the end of my career as a trial lawyer, I thought I had a real strong understanding about the impacts of our carceral system on the men and women that it sucks in. Having been a capital lawyer for a long time, I really thought I knew the environment that they were experiencing. And as the public defender here in Los Angeles, I thought I'd learned more in my short time here about what was happening behind the prison walls so that I could help educate my community, and by that I mean everyone that I came across, and share the message of what I understood. But when I read what Jane and Romarilyn wrote that was shared with me by Grace, I realized that I was missing such an amazing part of the conversation, such an important part of the conversation that I didn't really understand. Our prison system brutalizes human beings every single day. We see it within our pop culture, and most of us begin to understand it, even if only on a superficial level. There's much more information at our fingertips about how over-incarceration destroys lives rather than making us safer. As Romarilyn mentioned very clearly, or excuse me, Jane mentioned very clearly, when you start adding time to a person's sentence, it doesn't make us safer as a community. In fact, the opposite happens. The opposite happens not just because of the impact on the person in custody and what they face when they get out, but the impact on the families and the communities from which they come. Those communities are ravished and deprived of critical and important members who historically contribute more good over time than the negative images much of the fear mongering would have you believe. But what I was missing, what I didn't understand, and what I learned from Jane and Romarilyn was the impact on our elderly and the brutal and significant impact on women. I was shocked and truly offended to learn that after being forced to work, think about that, forced labor, that the very benefits that you and I take for granted, Social Security, was denied, that there was no option to receive it. Oftentimes because their incarceration started at such a young age that there was no history of having worked before, and the work done in prison provided no future benefit. I began to try to wrap that around my brain. The understanding that when you leave prison and you're elderly and you haven't worked in the outside world and you haven't seen it for decades, any support network beyond your family is gone. The means to buy food, the means to seek medical treatment, the means to do some of the very basic things that bring us joy as human beings at a later stage in our lives. I was raised by two women, a single mother and my grandmother, who immigrated here from Mexico. We had very little. I remember times where peanut butter and jelly or cornflakes was an exciting meal. We were on welfare, and I saw the brutal difficulty it was for both of them to work and provide for the four of us, my siblings, my three siblings. I saw how hard it was for my mother, with barely a high school education, to get a job that made enough money to support her family. And my grandmother, as an elderly American, Mexican American, to get jobs that would supplement that. And I began to imagine what it had been like had they come from prison, had they experienced half of what Jane and Romarilyn had experienced, the difficulty and the brutality of that. And that was something that I hadn't conceptualized until reading their pieces. I hope that after we listen to them more and you learn more about what their experience has been and the reality of this carceral process, then not just your minds will be open to learn more about it, to write more about it, not just your hearts will be open to empathize more about it and to care more about what happens with them, but that action will be risen within you. We live in a society today where we are struggling, we are fighting for equity, to be anti-racist, to create an environment where LGBTQ are treated with dignity and fairness in every environment, where women don't earn less money than men for equal work, for basic humanity and dignity. And just saying that is shocking, that in our own society, we're struggling for that today. And yet so many of us are ignorant, blind to what goes on behind the walls of our prisons, where those basic wants, those basic desires that we struggle for are ignored and brutally shut down. So please join me today to listen like I did, to learn, and maybe realize that you don't know as much as you think you know, no matter how much you read about it, but that the people who have lived it have so much more to share with us and teach us so that we can make real change tomorrow. Thank you.
Thank you, Ricardo, for those remarks and for the call to action for all of us here today. So I'm just going to get going with a conversation between the three of you. Before I start, I do want to let folks know that since a lot of people are likely here for MCLE credit, just so you know, you do have to attend the full session, and if you do, you will receive an email asking you to sign up to receive the credit, and that will all be done through email. So I wanted to ask Romarilyn and Jane to uplift. In both of your briefs, you really talk about the impact on, of aging inside of the carceral system, particularly for people inside of women's prisons, and what that impact, both physically and on mental health, what you saw, what you experienced, so that we can understand the full breadth of the issue here. So maybe I'll start with Jane and then go to Romarilyn.
Thank you, Alicia. I'll mention two particular things that happen behind prison walls. One is, and I think Romarilyn mentioned it, there is no ability to retire. It doesn't matter how old you are, you work in prison. And believe me, there's no consideration for what kind of work. I've had to intervene through the Golden Girl group when 70-year-old women are placed in positions in the warehouse, lifting heavy boxes all day. And you don't have an option of not going to work. If you don't go to work, you get a write-up. And of course, for any lifer, that's the kiss of death. You'll never get parole if you have a write-up. And so you have to work. There's no other option. The other thing that's very debilitating for elderly, and Romarilyn has already said, and I completely agree, health care in the prison system is awful. They've learned to cover their rear ends pretty well with documentation, but providing actual care. And when they do take particularly elderly out for a transport to the hospital to have some kind of an outside test done, it's always done with the elderly being shackled, feet shackled together, arms shackled to the waist, and then you have to try and walk with that into the medical facility. I did a little informal study at the numbers of so-called escapes. That's why you're shackled, in case you would try and escape. For an elderly who's been disciplinary free for 20 years, do we really think now they're going to choose this opportunity to run away? But the number of falls that occur when women are trying to walk with shackles, the number of bruised and bloodied ankles, etc. Most elderly women now refuse going out on transport because of that, further jeopardizing their own health. So there are so many brutalities within the prison system done under the guise of public safety with zero consideration for human dignity or support in any way. And most of them completely illogical. As I said, what 70-year-old woman is going to try and run away now after 20 years of being disciplinary free? So I'll pass it over to Romarilyn.
Thank you, Jane. I just have a couple of things to add to that. I think you covered a lot in such a short time. Thank you so much. I just add that there are, let me just back up a second. When I was incarcerated in the early 2000s, we saw an alarming number of young women coming into the prison, and that prompted us to create the Young Adult Networking Group, YANG, for young people 18 to 25. Many of these young people were sentenced to life and long-term sentences. Coming into a brutal prison system at 18 years old, 19 years old, 20 years old, being sentenced to life, a virtual life, or life without the possibility of parole is basically sterilization by incarceration. And I don't think people think about that, especially considering that, there are a number of people now being released through executive clemency, through commutation, through the parole board, that one day a lot of these women will be released. And, if they want to have families, they won't be able to have families. That's just one of the things I want to point out about long-term sentences and the impact it has specifically on women. And then I guess more to the point and to your question, Alicia, 90% of all women who are incarcerated have experienced years of violence, sexual trauma, and all kinds of other violations in their life. Being incarcerated in the facilities that we have today, these environments continue to victimize us. They're not therapeutic. They don't provide us with the right supports inside, correct resources for women who have experienced years and years of trauma. And having women's facilities that are primarily staffed by men who don't understand trauma, trauma-informed care, who don't understand women for the most part, it's just a disservice to those incarcerated. It's a disservice to the idea of rehabilitation. And it just creates a culture of continuing to do harm to incarcerated people. And I think there's one other thing, and we don't have to go into detail about it, visiting and nutrition. You know, visiting at family reunification, keeping those bonds with your family. There's not enough time for women to create those strong bonds because most women who are incarcerated have children. And so we need to think about and reimagine ways to create more visiting opportunities that are nurturing, that help to sustain families for the long run, and more nutritional value. And I won't get into, Jane's a nurse. She knows more than I know about the importance of nutrition for a female body. But the prison system does not provide these things. So with poor medical care, poor nutrition, poor housing conditions, the impacts of trauma, the impacts of long-term sentences, you know, the idea that we are forced to work, you know, well into our senior years is, you know, it just makes for a very tyrannical and brutal system.
Yeah, and I want to ask, bring you into this, Ricardo. You mentioned, you know, hearing all this and reading Jane and Romarilyn's policy briefs, that it really got you thinking about things that maybe you didn't know, right? Even after being a public defender for so long. And so I want to start with you, but then ask our other panelists as well, sort of, what do you think the role is or should be for public defenders in, you know, talking with clients about what they're about to face, about what this sentence means, and really understanding these sentences to really advocate for their clients as best as possible?
The first part, that's easy. I think a public defender should always be transparent with their client as to what the sentence really means. There shouldn't be any glossing over about what that long-term impact is and what it means, at least when I was practicing, what it meant for someone to get an L at the end of their sentence. And what I mean by that, if it's a sentence, is 25 to life, 7 years to life. People are being paroled now, but there was a time that if the L was attached to the back of that sentence, there was no hope of parole, right? And people would go into prison believing that they would be there for the rest of their natural lives. And that was a reality you should be telling an individual before they make a decision whether to accept a plea or to go to trial, because oftentimes that life sentence is dangled over their head by the prosecution, not every prosecution, but by the prosecution, to entice them to a high numerical of 20 years. And when you're looking at life and the belief that you'll spend the rest of your life in prison, the fiction of 20 years or even 25 or 30 years as a viable alternative begins to sound a little bit better. And you have to be really honest with the individual what that means, and never try to encourage them, I believe, to make that decision based on your own ambitions as a trial lawyer or as an individual human being. It's got to be about the client. The other part of that conversation, which is brutally difficult, is oftentimes you're having that conversation with a young man or young woman who is under 20 or in their early 20s. And I have a 13-year-old son, and as much as he thinks he knows everything, he doesn't, right? And we've all dealt with young people. They begin to understand themselves in the world right around 13 and 14. And so you're speaking to a person who is 19, 20, 21, who's only really begun to develop that independent, adult transition identity. I know some psychologist is going to blast me for this, but I'm trying to make a point more than an accurate science diagnosis. You're trying to tell them then, after they've really been trying to build their independence for 5 or 6 years, that they should accept a sentence that is 19, 20 years, longer than they've been alive, longer than they've been thinking about what they're going to be doing tomorrow, longer than the world makes any sense to them. And they can easily say, oh yeah, sure, because they don't conceptualize in those ways. You have to make sure that it's a hard, how do you talk to them that way? How are you honest about that without disregarding that. Thankfully, laws have changed drastically on the impact of incarceration to young people as we've learned more, as the courts and the prosecutors have learned to accept more about what the brain development is, that we are not influencing these kinds of things. But the end point is you need to be brutally honest about what that impact is going to be. And to do that, you have to educate yourself. And that's why I said at the beginning, I thought I understood. I thought I knew what that was, but this was an aspect of it that had never crossed my professional career, which is the Social Security, the work, and what happens afterwards in that respect.
Marilyn or Jane, do you have any response to that question, or what Mr. Garcia is talking about around, the public defender's role, or even your experiences with your attorneys? Jane, go ahead.
I'll just jump in and say, I think it's important for everybody to know that no lifer goes before the parole board looking for parole suitability until they've served their term. And there is a presumption in the penal code that you will be found suitable. So why is it that we have such a low suitability rate? I mean, I get it. People talk about the Willie Horton effect and so forth. For God's sakes, we should let somebody out that does something, and nobody wants that. But to go so far the other way, where it's costing taxpayers so much when we could be doing so much more toward providing public safety by utilizing those funds differently. So I just think it's very important to realize that there is a presumption of parole and it's not being utilized, and the parole commissioners have to get up to speed. Thank you.
Thank you, Jane. I just add that, thank you so much, Ricardo, for your remarks. Public defenders just need to be honest and real with their clients. But first, they need to know the facts. They need to understand what a life sentence means. And I don't think that they fully understand that. I don't think they fully understand that folks don't parole just because there's some language in the California Code of Regulations. It doesn't work that way. So many of us have been misinformed by our public defenders. And many of us, don't understand that when we take pleas or when we are sentenced to life, really what that means. So I think, Mr. Garcia, there needs to be a lot of education around what a life sentence is and how that plays out within the prison system and what's going to be available to people once they arrive at the gate and what their plan should be on how to get out of that cage. So there's a lot of things that I think the public defender's office can work with their clients on during the trial, after the trial phase, and even while they're incarcerated, those first months or years, they can continue to, I think, guide them in ways that would be really beneficial to their time while they're incarcerated.
Thank you for that. I'm going to ask one more question and then open it up to the audience. So we've talked a little bit about some promising legislation and things that are changing in these processes. And I wanted to get all of your opinion on, in LA County, we have a new district attorney, George Gascon, and some of his new policies include that the district attorney's office now will reevaluate and consider for resentencing people who have already served 15 years in prison. He also states that the DA's default position will be to not attend parole hearings and instead to write a letter of support in the granting of parole with some limited exceptions. And I'm really curious to know, what are your thoughts about these new policies? Do they go far enough? Will it address some of these issues?
Okay, I'll jump in. I would like to see, again, following the research, I would like to see him adopt a review all sentences of 10 years. Because again, the research shows that it's counterproductive for people to spend more than 10 years in prison. It's a downhill spiral. Yeah, all of prison is a downhill spiral anyway, but I do very much appreciate his willingness to support parole, because, and I know Romarilyn can tell you the same thing, in looking at parole hearings, even for women who, as I say, a single crime, disciplinary free, so forth, the district attorney in the past would show up and always object to parole. I could count on one hand the number of times the district attorney has shown up and said, yeah, I think this person I support parole. So in many cases, it's certainly not the same district attorney because it's years later. They review some kind of record. They don't really know the person. They just, by a standard, say, oh, I guess our job is to object. Our job is to oppose parole. And that's just a ridiculous stance. So I'm very grateful that George Gascon has made those initiatives. I would like to see him go a little bit further. But first, I would like to see the DA's union back off.
Yeah, thank you, Jane. I don't think there's a need for the DA's office to be a part of the parole process whatsoever. There's no need. You know, unless there is a clear nexus between the crime and who the person is today. The parole hearing is a hearing that's about your progress, whether or not you are suitable for release. We've gone through a psychological evaluation, years of incarceration, have gained insight, have parole plans, impact statements, you name it, a long list of things that we have to do. And I had 7 parole hearings. So I know this process very well. There was no need whatsoever for the district attorney to show up in my case or any case, because we're not trying anyone. The trial has already taken place. So if we really want to push this to another level, we really want to do something progressive, then we don't need a letter from the DA of support. We don't need a video conference. We don't need them to show up. We don't need them. We've done our time. We have reinvented ourselves and we're ready to move forward. And if they can't support that, they don't have, we have no need of them in the space. That's supposed to be the parole board's job. They get paid over $125,000 a year to be a commissioner and to be able to have, the wherewithal, the judgment skills to make those determinations. So we can save a lot of money with just cutting out the district attorney's part in parole processes altogether.
If I could just jump back in for 1 minute.
Absolutely.
I just want to say, Romarilyn is being very humble, and I appreciate it, Romarilyn. But I want everyone to understand, Romarilyn just said she was in front of the parole board 7 times. Romarilyn is somebody who earned a PhD in prison. She worked tutoring other college students. She was head of the Women's Advisory Council, voted in by her peers to represent the community with administration. If she's not eligible for parole and has to go through that process 7 times, who the heck do we think is going to be? So I think it's really important to recognize how slanted the parole board is. And until we fix that, we're going to continue with long-term sentences. Thanks.
I hesitate at this moment to sort of bring it back to our local district attorney because those points are exceptionally well made about the failure of the parole board, about it's not doing what it's supposed to be doing and not looking at individuals like Roland, the perfect example, who's accomplished more in prison than most of us accomplish out of prison, right? And how we would value someone, how we would sing the praises and the accolades of someone who accomplished what she accomplished outside of the carceral system, let alone in it, and how that those accomplishments are dismissed as insignificant is inhumane. To answer the part about our DA, we are, as a public defender, being a public defender, you become very cautious about change. The directives and the direction in which George Gascon is moving his office are things that public defenders, those in Los Angeles and across the country, have been asking for decades. They're changes that activists and reformers in the criminal justice system, many probably in this audience, have been begging for and showing are absolutely the most rational, intelligent, and science-based approach to our criminal justice process. And don't take it from me, the advocate for the criminal justice process, take it from the science. So to have a prosecutor who's not just taking baby steps or sticking his toe in the water to make sure it's safe or warm, but is going in full throttle, full-throated, is an absolute optimistic, hopeful joy. We'll see where we go. It's too early to tell where we'll end up. I remain hopeful. I believe that George Gascon is honest and true in what he wants to do and what he believes, and that may be enough. He is facing considerable opposition, but change is painful, and fear-mongering is a way to add the pain and fear and the horror of change. We know that the practices of the 90s and the 80s and the early 2000s, the mid 2000s don't work. Having more prisons than universities is irrational. Touting ourselves as the freest, most progressive country in the world and having more people in prison than other countries that we call less civilized is not an honor we should have. We should not be competing with them to see how many of our fellow human beings we can cage. I'm excited about his move on 1170D to bring back individuals who have been sentenced as young men and women and have been spending a significant time in prison to come back and give us the opportunity to show how they deserve to be resentenced and released, not just because they're medically fragile. We should absolutely release the medically fragile. Not just because they're elderly. We should absolutely release the elderly, and not just because they've had exemplary behavior in prison, who we should also be releasing. But those men and women who sometimes we think, well, they're not perfect, we shouldn't release them. No human being is perfect. We need to start understanding that and not expect perfection of people that we put in a brutal situation. So I am excited and hopeful that we will get resourced enough to do that work moving forward.
Thank you so much to all of you. So I'm going to turn to some audience questions. The first one is for Romarilyn. You spoke of the numerous critical criminal justice policy reforms that you and your coalition have worked to change. And as an abolitionist organizer, can you speak about your perspective on what abolitionist reforms versus reformist reforms look like?
Okay, sure. Thank you for that question. I think when it comes to policy and when it comes to policies that impact incarcerated people, and that's most of the legislation that I've worked on with our coalition partners, I think there's no really clear-cut way to define reforms and abolition, because we're all working towards reducing the harms and dismantling systems of oppression at the same time for our people. And if our people inside need to have some of the burdens removed, the cost of incarceration removed from them, I think that is, a reform that can also be seen as dismantling a system of oppression, the exploitation of incarcerated people. Just like with abolitionists, and I consider myself an abolitionist that's always working towards dismantling, the prison system, but not just the prison system, all systems of oppression, whatever form that it takes. And so I think that a lot of us who are working on these policies that are reducing the harms for incarcerated people or members in our communities are doing abolitionist work, while we also work in coalition with organizations like CURB to close prisons. But, our recidivism rate here in California is decreasing. It is still 50%. It's still way too high. It's not the 64% that it used to be. we now have a deeper and richer understanding of what people need when they return to the community. And so in providing some of these reforms to get folks better access to education, better access to employment, to reduce some of those 48,000 barriers which people face, we are closing prisons by providing those resources and services, while we also advocate and demand that the physical structure of a prison is also closed.
That was so beautifully put. I just really appreciate that framing of the both and of doing all of those things at once and really looking at the long-term impacts and goals of this organizing. And that brings me to the next audience question. I think you know, what's been so alive in this conversation is the incredible acts of resistance that go on inside of carceral facilities that have happened throughout history, right? The organizing, the support networks that folks form, the community, and the advocacy that you all are able to engage in on the inside and connecting with folks on the outside. And so Jane, you know, you spoke about the process of the parole board being subjective and containing a politically built-in bias and discriminating against the elderly and people of color. Can you talk more about the type of organizing work of people inside and outside and what they're doing to reform the parole process and how these reforms navigate carve-outs that inevitably arise in policy work?
Thank you. That's a great question. And there's a lot of organizing that goes on inside through the long-termers organization, which is really open to anybody serving any kind of a lengthy sentence. It's up to you to determine how lengthy you want to join the organization. But the whole push with that organization is to find some way to support people inside. Again, because of the systems of oppression, because of the nature of the prison system, so domineering, so keeping prisoners in their place. It's very hard for many women to feel like they have any kind of support, to feel like they have any kind of voice, and also to risk using that voice because retaliation is alive and well in the prison system. I've had incidents where I've helped people create what's called a 602, which is the internal appeal process, because for whatever reason, the bureaucracy within the prison system is keeping somebody beyond their legal release date. Oh, the paperwork hasn't come through. We know you were supposed to be released last Tuesday, but what's a few days? And I've been called into the program office to say, why are you doing this on behalf of that person? What's a few days? And that's the culture inside, you know, shut up and just take what there is. So organizing first and foremost to allow women to see that they do have a voice, and collectively we can come together and push for things. And again, making it very clear that yes, people have to do a lot of work to get ready for the parole board. They have to participate in a lot of ways, but being denied parole is not necessarily their fault. When you just simply look at the statistics, the system is way against you to start with. So being able to support women through that process and being able to encourage them to get other people involved, get families involved, simple things like write letters. I always used to say inside, if a legislator gets 1,000 or even 100 letters around a particular subject, they're going to pay attention. So just mostly doing things like that, letting women know what they can do inside, I think is very important.
May I speak to the carve out piece? So it is very difficult, very hard when a piece of legislation that advocates and organizers have worked on and we've submitted language and it's inclusive and it's good legislation. It's good, it helps all of our people, is put forward, and then for a number of reasons, whether it's bias or the budget or stigma, things are changed. And oftentimes when it comes to legislation around incarcerated people, folks with 290s classifications or those with sex offenses against minors or sometimes those serving life without the possibility of parole have oftentimes been left out of some really key pieces of legislation. It is never easy to do. It's never easy to do. Oftentimes we who are organizing on the outside reach back to our peers inside and say, you know, on this particular bill, we're being asked to amend it this way. And we ask their permission, we ask their input. CURB, Ella Baker Center, Initiate Justice, they're really great at doing this. California Coalition for Women in Prisons, of course, we ask our members inside. If we stay on this piece of legislation, you know, this piece is being removed, this population is being removed. And, you know, we ask for their weigh-in, their input. And so it's never an easy decision when that happens. And when we have to take those amendments, you know, we take them in such a way that we can come back later to get them. You know, we try to build that in so that they're not permanently left out. And I think we're seeing that now with the Racial Justice Act, you know, and we are now working towards getting that retroactivity piece passed this year. So those of you, we will be calling on you this year to help us push retroactivity so that it can impact those incarcerated who, you know that there's racial biasness in their case. So it always breaks our heart, is the bottom line, to have to leave our people behind, regardless of their crime and regardless of their time.
There's been a couple questions around victims in the system, and I want to get all of your reflection on this and nuance the conversation. So Jane, you mentioned the CCPOA and you know, really advocating for victims' rights, but from a certain perspective, it's the prison guards union, right? A lot of law enforcement is involved in the victims' rights movement. There's been a lot of efforts, though, recently, I think, from victims saying, actually, no, here's something different. We don't want the adversarial process. We want something different. And on the other side, and something that really is a huge part of public defenders' work, is to really show how quite frequently people who are charged and accused of crimes are victims themselves. And you all also mentioned this, right? The survivors of domestic violence being incarcerated for defending themselves, for example. And just, you know, a whole load of trauma coming, you know, in the lives of people who are over policed and over incarcerated. And so I'm wondering what, this is one of the questions from the audience that dovetails with this, is sort of what policies could be implemented to address trauma before people even have contact with the criminal legal system. And, you know, from the attorney's perspective, what do you do to kind of nuance this idea of what the definition of victim is, right? And then thirdly, how do we bring victims into this movement so that we're moving away from the adversarial system and addressing all of the needs and harms that, you know, violence and trauma really bring to the surface?
Let me jump in on this one, just on one part of it. I think it's important as public defenders, as attorneys, from a legal perspective, that to acknowledge that the person in court, the victim, is a victim. They may not have been victimized by your particular client, but something has occurred and they've been victimized. And so we have to honor their position and feeling at that time. We have to acknowledge it. We can't minimize it or attack it directly, particularly in the hallways or in their sense. We have to honor that feeling because that feeling is real. I have found in my own experience that when you do that, even when your client is involved or responsible, when you acknowledge the family's pain and suffering at that point in time, you're more likely to get an empathetic response from them, for them to see your client as human, for them to understand that there is not just one side to this conversation, and they can be supportive. You see that happening in capital work all the time, where groups reach out to victim families, to victims of these crimes, to try to bridge that gap and open a line of communication. It's not always successful, but you have to begin that process there. You have to acknowledge the story and the victimization of your client. I mean, that's a very real statement. Studies are clear that men and women in prison have been victims, not just of physical violence, not just of emotional violence, but of sexual violence. They have been brutalized by sometimes the people that they trust and they believe should be caring for them the most. And to disregard the impact that has on them and their psychological development and their emotional growth is to victimize them again. And so it's important to take those two sides that are in pain as the attorney, understanding you're there to advocate for your client, but not disregard them. And there are ways to do that. There are holistic practices to reunify communities. Violent crime doesn't just harm the families, it harms the community. And we have to acknowledge that and work within the community. Now, it's an example that was often used in cases that I had, gang cases, as they were called, was that a gang murder or a gang robbery somehow terrified the community, made everyone afraid to go outside. And that enhanced the fear mongering around the idea of gangs. In violent crime in any community, regardless of who does it, creates fear and anxiety and tension and concern. And we have to acknowledge that reality and allow ourselves to communicate and to own that. I know it's a little bit vague in the answer, but I just think that we spend too much energy and time polarizing that conversation because of the few times we are actually in court adversarially fighting against one another. Most of these conversations, the reality of the criminal legal system is that the conversations occur without a trial, where those kind of healing and respect and understanding and listening can actually occur.
So on the front end, I think what we need to do is divest from corrections and law enforcement, push more of that money, into community needs and community programs. That's where the investment should be. So if we want to prevent members of our community, our marginalized members of our community, our Black and brown people of our community, our poor people in our communities from being incarcerated, there needs to be an investment in our communities, a real substantial investment. And that investment needs to include, transformative justice practices, building community accountability, making sure that the resources are there, the people are there on the ground to intervene, to support, to provide, care for their neighbors. We don't need law enforcement to care for our neighbors. We need to care for our neighbors. And so there just needs to be a greater investment there. And so much has been written about community accountability by Miriam Kaba, by Alicia Virani. I mean, that's where we need to invest our money. If we want to continue to increase public safety and decrease recidivism, we need to start investing in our communities.
If I can just jump in again on that, because I didn't touch on it. That's one of the exciting things I think that we're seeing here in Los Angeles. With the Alternatives to Incarceration report back in, with the movement that is taking it, the Care First, Jails Last thinking, we are talking in real dollars and real sense about preventative care within the community. Looking at why people end up in the criminal legal system, what are the realities of their life, and taking steps, real steps to stop that. Not waiting till they get into the system, but intervening before they get into the system. But I want to be, from my perspective, I think what's also important with that is that the right to self-determination. As system actors, as part of the process, as government offices, as agencies, I don't think we need to, it's not for us to solely go in and tell communities what they need, to tell communities what resources or what support or what help they need, but to listen. I love what Roman said about neighbors caring for neighbors, allow communities to care for each other. That's where the trust is. And And I will say that idea within the Alternative to Incarceration, ATI, is a breath of fresh air within Los Angeles that I hope not only takes real root here in our communities in this county, but spreads like wildfire across the country to make fundamental long-term changes. As a public defender, if I run out of work because there are fewer and fewer people going into the system, I'm not going to lose sleep. Where I lose sleep is all the individuals that are in the system that I can't help. All the resources that my attorneys need and want to do the incredible work to do that I'm having difficulty getting. That's where I lose sleep. I will not lose sleep if we have less to do because the system is keeping more people from going into it.
Thank you. We're out of time, but I want to give every panelist just one last opportunity. Ricardo, you mentioned the Alternatives to Incarceration work group. Jane and Romarilyn, if you can just say really quickly how anybody here, you have a captive audience of over 500 people, how people could get involved in the incredible work that you all are doing. And then I'll, after you finish up, we'll hand it off to Grace.
I'll just invite everyone to check out our website, the California Coalition for Women Prisoners. That's womenprisoners.org. If you want to know more about Project Rebound, you can go to calstate.edu/rebound. Or if you want to know more about our program at Fullerton, it's fullerton.edu/rebound.
And I will just echo what Romarilyn just said. There are so many opportunities where people can get involved just by sitting in their armchair. All of these organizations have amazing toolkits to be able to advocate for a particular somebody's release, an issue going to the governor. And again, if legislators and the governor and folks hear about it over and over, they're going to do something about it. So we try and make it simple. Get involved, write a letter, send a message. Again, if a lot of those messages go forward, these great organizations do the work for you. You just have to plug in your name and maybe 2 minutes to create an email, and there you go. So please do get involved.
Thank you so much to all of our panelists. And Grace, I'll let you close us out.
Well, that was just, I'm stunned. I'm speechless. That was so wonderful and amazing. You know, thank you all again so much. Alicia, thank you for masterful moderating. That was really wonderful. Just to say that Jane and Romarilyn's policy briefs are available on the CSW website, and we'll be putting up a recording of this event on the website as well. We'll email everyone when that's up. So thank you to the LA County Public Defender's Office and to the Criminal Justice Program at the UCLA School of Law for co-hosting this event, and to the UCLA Promise Institute for Human Rights, also at the UCLA School of Law, for co-sponsoring. And most importantly, thank you to all of you who attended. We hope to see you at future CSW events, both virtual and hopefully soon in person. Thank you and have a good day.